Immediately start to move for judgment.
The impugned judgment requests no interference. The same is confirmed. JCRL is dismissed. The appellant, who is on bail, is directed to surrender for the court within 15 days of his complaint.
I agree. Yes.
Item number 13. May I please, members?
Around 47 रो पेपर बुक देला.
39.
Yes, sir. It's JCRL 49 though.
Yes, madam. Yes, madam. Date of occurrence is 24/3/2006, madam.
302 case, no?
Madam,
Yes.
302 case, madam.
Okay, please come to the FIR. Let us see what is the
Madam,
prosecution
madam,
case.
madam. Page 15, madam. Written FIR.
Yes.
लिखी जरा कारण ये कि जे मोर नाम राजेंद्र छत्रिया.
It's
राजेंद्र छत्रिया
PW1.
PW1 madam.
Yes.
सुआंशो अद्यता 24/3/2006 दिन 1 घंटा समय मोर भणजा रोशन मुना लोईसिंगा आसी खबर देले मोर बापा सदाकर छत्रिया को लाजर छत्रिया
मोर भणजा रोशन सुना.
आज्ञा
रोशन सुना is PW6.
6
Okay.
आसी खबर देले मोर बापा सदाकर छत्रिया को लाजर छत्रिया टांगिया रे तांकर कपाळ उपरको हानि देबा.
Sodhakar Kshatriya is the deceased and he is the father of the informant.
Father of the
And Lajar Kshatriya is the appellant, right?
appellant.
Yes.
ମୁଁ ସଙ୍ଗେ ସଙ୍ଗେ ଆମ ଗ୍ରାମକୁ ଯାଇ ଦେଖିଲି ମୋର ବାପାଙ୍କର ମୁଣ୍ଡରେ ଧାରୁଆ ଅସ୍ତ୍ର ଦ୍ୱାରା ଗୁରୁତର ଆଘାତ ହୋଇ ରକ୍ତାକ୍ତ ହୋଇ ପଡିଛନ୍ତି. ମୁଁ ମୋ ସ୍ତ୍ରୀ ଏବଂ ଅନ୍ୟମାନଙ୍କୁ ପଚାରିବାରେ ଜାଣିବାକୁ ପାଇଲି ମୋର ବାପା ଗାଧୋଇ ଯାଉଥିବା ସମୟରେ ଲାଜୁର ଛତ୍ରିଆ ଆଦ୍ୟତା 24/3/6 ଦିନ ପ୍ରାୟ 11:30 ସମୟରେ ଟାଙ୍ଗିଆରେ ତାଙ୍କ ମୁଣ୍ଡରୁ ହାଣି ଦେବାରୁ ସେ ମୁର୍ମୂଷ ଅବସ୍ଥାରେ ପଡିଛନ୍ତି. ମୁଁ ସଙ୍ଗେ ସଙ୍ଗେ ଗାଡିରେ ଆଣି ଡାକ୍ତରଖାନାରେ ଦେଖେଇବାରୁ ଡାକ୍ତର ତାଙ୍କୁ ମୃତ ବୋଲି ଘୋଷଣା କଲେ. ତେଣୁ ଲାଜର ଛାତ୍ରା ମୋର ବାପାଙ୍କୁ ଟାଙ୍ଗିଆରେ ହାଣି ମର୍ଡର କରିଥିବାର ଦାବି ରଖି ଏହି ରିପୋର୍ଟ ଦେଉଛି. ଏହାର ତଦନ୍ତ କରାଯାଉଛି.
So, is there any eyewitness to
PW 216. PW 216. Son and grandson.
Just son and wife of the PW2 is the
eyewitness.
PW2 is the wife of the informant. Acha, wife of the informant. And out of
PW6 is the grandson
of the deceased.
Roshan Suna.
Okay, so you start with PW2.
My lord. Page 26, my lord.
Yes.
The accused in the dock is distantly related to us. The incident took us on 24/3/2006 at around 11:30 a.m. on the backside lane of our house. The accused was visiting our poda regularly and making halla in front of our house and abusing us. By the relevant time, when my father-in-law was moving to village tank to take his bath, he forbade the accused from making a noise. But the accused, who was holding a tangia, dealt a blow on his head with the tangia. My father-in-law raised a scream, morigally, morigally. Hence, when I rushed to the lane, I found the accused taking out the tangia from head of my father-in-law and leaving the place with the said tangia, whereas my father-in-law was lying on the road with a bleeding cut injury on his head. I raised Halaman. Other neighbors also rushed to the spot. My nephew and Roshan Suna went to my husband and informed me the incident. After arrival, PW1, my father-in-law, was shifted to hospital in a vehicle. Cross-examination. The accused was not
mentally deranged.
He was acting like a mad person. It is not a fact that the accused was in Bargad on the relevant day. It is not a fact that he was not in your village and he did not make any hala. I had been to village tank at about 9 a.m. It is not a fact that I have not seen the accused at the spot and I am deposing falsehood implicating. It is not a fact that I have not heard any hala and that I have not seen any incident as described by me. It is not a fact that my nephew was in the college and that he was not sent to my husband.
Okay, come to PW6 then, let's see.
Page 33, my lord. I know the accused and the informant. The deceased is my grandfather. The incident took on 24/3/2006 in our house in village Sujia. On that day at around 11:30 a.m., while I was sitting in the veranda of Upendra after returning from my college, I saw the accused Lazar Kshatriya moving towards a house, brandishing an axe and uttering brandishing an axe and uttering obscene words. The deceased came out of her house and seeing him, the accused dealt a tangy blow on his head. My grandfather collapsed to the ground, being struck by tangy blow. I rushed to the deceased. The axe was pierced on the head portion of my grandfather and left affixed. The accused dragged the same from deceased's head and left the spot with I sent information to my uncle. Then I proceeded to Louisiana to arrange a vehicle to shift my injured grandfather to a hospital. I met my uncle Rajendra Kshatriya in Louisiana and described the incident to him. We took a vehicle to our village and shifted the injured to Louisiana Government Hospital, where he succumbed to injury later. Cross-examination. Sujia is my maternal uncle's village. My father's house in Bargod town. I have been staying in village Sujia with my mother since my childhood. I attended my college on that day at about 9:30 a.m. On that day, one periodical examination was held only. I go to my college in a cycle and it took me 15 minutes to reach there from my uncle's house. My class was over at 10:20 a.m. and I returned home at around 11 a.m. I cannot say the exact time when I arrived in my house. Before attending class in my college, I met the accused in Louisiana. He was sitting in a welding shop at Louisiana. I cannot say the time when I met him. The accused stays in Bargod town. Though he is not an inhabitant of Sujia village, he came to the village at times. It is not a fact that the accused is a mentally derailed person, and on that day he was mentally derailed. Whenever he came to village Sujia, he used to rebuke someone. The accused was rebuking my grandfather and another person while he was moving towards her house. The house of Upendra is close to my grandfather's house. My grandfather returned home after visiting his agricultural land. I did not see any other villager on the village street when the accused was moving towards her house. The accused came from north direction of her village. The accused escaped towards river bed of her village. He dealt a single blow with the axe to my grandfather. I did not raise any scream to save my grandfather when accused assaulted him. We reached in Louisiana Hospital at around 1:30 p.m. I cannot say if my uncle came to Bolangir on that day to attend his duty. I met the informant near Louisiana bus stand. It is not a fact that The accused did not come to our village on alleged date of incident and that he did not assault my grandfather, that I am deposing falsehood. I was examined police in the evening of that day.
Now you come to the doctor's evidence.
P 7 man.
PM doctor tho?
P 7 man. Page 35, next page man. On 25/3/2006.
25/3.
My lord, 25/3/2006. I was working in the present capacity. On that day, on police requisition, I conducted postmortem examination of one Sadhakar Kshatriya, son of Bhaskar Kshatriya of village Sujia, P.S. Loisingha, and found as follows. The deceased was a male of 62 years, stout, bloodstain of his body, rigor mortis present, lower limbs absent on neck, muscle, and upper limbs. Inside of size 7.5 centimeter length into 0.88 cm into 5.5 cm, depth present horizontally, horizontally 1 centimeter, right midline of front parietal partial region. Margin sharp and contusion. On dissection under line bone was found fractured into multiple features. A piece of bone is missing. A piece of bone entered into brain matrix. There was subdural and intracerebral hemorrhage. There is destruction of brain material, mostly right frontal bone. The other organ like heart empty, lungs spiraling over were intact and pale. The injury has antenatal nature. Death was caused due to injury to the brain. Time of death was within 36 hours prior to the PM examination. The injury was sufficient to cause death of a person, and the injury could be possible only from acts. The deceased was identified by Constable 336 Narendra Bhagarti and Constable 645 Jogendra Dharwa. Exhibit 6 is my report. PM report with my signature, Exhibit 6 by 1. The PM was conducted at 9:30 a.m. of 25th March 2006. I do not recollect time taken for conducting the PM examination. PM attendant assisted me, whose name I do not recollect. During the PM examination, I have seen acts. The weapon offense was not referred to me for my examination and opinion. The injury could be possible from a single blow.
So, any evidence has been adduced from the accused side, because it appears that some kind of hint has been given regarding plea of insanity. So, any doctor's evidence or any other material?
No evidence. That's why the Lord trial court has disbelieved.
हाँ, कारण खाली सजेशन देले ता मुंडो खराब ये या छोड़ा आउ किसी तो एविडेंस ही
Evidence said that's why the Lord trial court has disbelieved that. Only there is civil dispute between the parties and no
civil dispute.
P1 या question. P1 evidence टा replace कर दूँ.
आयो जो
आयो और P1 दी जना को civil dispute को.
P1 replace.
Again. Page 23. The accused standing inside the dock is distantly related to me. He is also a co-villager of mine. My father, Sadhakar Kshatriya, was deceased in this case. The incident occurred on 24/3/2006, which was a Friday, at around 11:30 a.m. on the backside lane of our house. When I was at Loisingha, at around 1 p.m., my nephew Roshan Suna came and informed me that my father was bleeding profusely on his head and lying injured on being assaulted by the accused with a tangle. When I immediately rushed to my village, I found my father lying on the lane with bleeding injury on his head. My wife disclosed me that accused dealt a tangy blow on the scalp of my father and left the spot, leaving the tangia there. But subsequently, he again turned up and took away the tangia from the spot. My father had a and he was inserting little. I immediately arranged a vehicle manner and rushed my father to Loisingha PSC. On his examination, Dr. Sethi of Loisingha PSC declared him brought death. I immediately presented a written report at Loisingha PS, which was scribed by my nephew Vijay Kumar Tandi as per my instruction, my lord. It was read over and explained to me and found the contents to be correct. Exhibit 1 is that affair with my signature. Exhibit 1 by 1, police sent the dead body. District headquarters of Balangir for postmortem. After making inquest over the dead body at Loisinga PSC, I was witness to the inquest. Exhibit 2 is that inquest report with my signature. Exhibit 2 by 1. On my production, police seized a cell deed in respect of our land, left the same in my Jima. Exhibit 3, the serial list with my signature. Exhibit 3 by 1 and 4 is the Jimanama executed by me for receiving the cell deed. Exhibit 4 by 1 is my signature on the Jimanama. Police made a seizure of a key hanging around the neck of my father and left the same in my Jima. Cross-section. By the relevant time, I was working in Netra Niketan, Balangir. I did not file an application for leave on 23/3/2006. My office hour was 9 a.m. to 1 p.m. and 3 p.m. and there was no time limit for our duty at times. I had been to the house, my in-laws at Loisinga. The accused was staying at Borgod for last 10 to 15 years, but he was visiting our village usually once in a week. The accused, Lajar Kshatriya, was not suffering from any mental disorder at any point in time. It is not a fact that the accused was mental disorder and he was not in a position to identify his death. It is not a fact that the accused was Borgod on 24/3/2008. Roshan Savna was staying in my house with his mother, and he was pursuing study in +2. It is not a fact that Roshan Sura was in his college and he had not met me at Loising on that day at 1 p.m. I reached in my village within 15 minutes of the information. Chandrakant Kshatriya is my wife. I cannot say when my wife had been to village to take her bath on the relevant date. The lane adjacent to the wall of her house. The houses are Radhananda, Satyavana Hanuman, Birendra Hanuman, and Gangadhar Behera, and others are located near the spot. There was no assault on my father in the spot described by me, and that the accused was not the assailant of my father, and the accused was not present in the village. That I am deposing falsehood.
ଏଇଟା କଣ ହେଲା ସିଭିଲ ଡିସ୍ପ୍ୟୁଟ ଟା କୋଉଠି ରହିଲା
Cell deed.
ଖାଲି ସେଲ୍ ଡେଟ୍
What is the age? On my production, police seized a cell deed in
ହଁ
respect of our
ସିଭିଲ
land.
ଡିସ୍ପ୍ୟୁଟ
Dispute between the accused and him.
This-
Nothing else.
ସେଇଟା କୋଉଠି
PW
8.
8 ମାନେ
ଆଚ୍ଛା ନାଇଁ
ପାରା
ଏଇ ସାକ୍ଷୀରେ କିଛି ନାହିଁ ଖାଲି ଗୋଟେ
Cell
ଖାଲି
deed.
ସେଲ୍ ଡେଟ୍ ହିଁ ଖାଲି ସେଲ୍ ଡେଟ୍ ହେଲା ଆୟ ଏଭିଡେନ୍ସ ଅଛି ପାରା 3
That is-
ଡେମାର୍କେସନ କଥା
we'll go to that
ମାଇଲର
I ହେଲା PW
8 ମାଇଲର
ଆଚ୍ଛା
ପେଜ 37
Para 3.
ପାରା 3 ମାଇଲର
ଚାରିଟା ଲାଇନ୍ पर yes para 3
Para 3 ମାଇଲର
now
On 19/5/2006, I made requisition to local RI for demarcation of the land where the alleged occurrence took place. On 11/6/6, I received PMA exemption report and the sketch map prepared by local RI. Exhibit 11, sketch map prepared by the RI on production by the complainant. I seized certified copy of a sale deed in respect to alleged land transaction by the accused in favor of the Subhagar Kshatriya and the land are in standing in favor of the
In
deceased.
favor of this.
Pilot, I
sale deed in respect of the alleged land transaction by the accused in favor of
the
One Suvankar Chatri.
what is the name of the deceased
Sadhu Kshatriya.
Shraddhakar
ROR stands in the name of this.
so ROR that stands in the name that sale deed was executed in the name of Shraddhakar. But who is the Subhakar? Is he relative or what?
Subhakar Chatri.
ହଁ ସିଏ ତାମାନେ ସିଏ ବିକିଥିଲା ସେଲ୍ ଡିଡ୍ ରୁ ଜଣା ପଡୁଛି ଯୋଉ ଆପେଲାଣ୍ଟ ହଉଛି ବାୟା ଆଉ ଇଏ ହଉଛି କ୍ରେତା ଏଇ ଯୋଉ ଶୁଭକର ଛତ୍ରୀ the land are was standing in the name of the deceased
In favor of
ତମେ
the
ସେ ଅନ୍ୟ ଜଣଙ୍କୁ ବିକ୍ରି କରିଥିଲ although it stands in the name of how is
the land on I see the certified in respect of the transaction by the accused and the land are oh. That means land stands in the name of the deceased, but the appellant sold it to one Subhakar Chatri. That is the sale deed. Acha. but किसी केस बस चलथिला बोली सेमती किसी ना
କିଛି ନା ସେ
Even that
actual-
thing is not in the FIR also, man.
हम्म
FIR ରେ ବି ସେ ସେଟା ଲେଖି
କିଛି ସେ କିଛି ଏଭିଡେନ୍ସ କ୍ରସ ରେ ଆସିନି କି ଡିଫେନ୍ସ କିଛି ଦେଇନାହାନ୍ତି।
ଏବଂ ଆଗରୁ ମଧ୍ୟ ଗୋଟେ ଲାଇନ କହୁଛି କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ ପେଜ 39 ରେ IO ଯେ prior to the incident middle portion ରେ during my tenure I had not received any FIR relating to quarrel or fighting between the parties for such land dispute। ତାପରେ FIR of course କହୁଛି ସେ land dispute ବିଷୟରେ କିଛି FIR ନାହିଁ।
And two co-villagers also saw him after assaulting when he was going back. Two co-villagers, they also saw him going lost
with
and
that
yes,
PW
of 3 and 4 years.
PW 3, 4.
Post occurrence
just we just place those that it
page
will be
28 my lord.
completed। Yes,
The accused in the dock is known to me, my lord has got page
you are
28
placing PW3।
my lord, page 28 my lord.
Yes, sir.
The accused in the dock is known to me, and so also the infant. PW1, the occurrence date back to 24/3/2006. On that day at around 11:30 to 12 noon, when I was about to take bath, Kusmal Nala, I found accused passing me, having bloodstain on his banyans. He was also holding a tangia with bloodstain. He saw me in a ridiculous manner. Being afraid of him, I did not take bath and returned home. On the way, I found deceased Sodhakar Kshatriya lying on the lane with a bleeding wound, blood on his head. Daughter-in-law and grandson of the deceased were found weeping near him, whereas other villagers were assembled near to the spot. Later, in course of investigation, police seized bloodstained art from the place where the deceased was lying, and I was a witness to the seizure. Exhibit 5 is that seizure list with my signature. Exhibit 5/1. Cross my lord. The accused was staying in Bargad. It is not a fact that the accused did never come to Sujil village. It is not a fact that the accused was mentally derived by the time of alleged incident and that he was mad prior to 10 years prior to the alleged incident. It is not a fact that he was not in a position to identify any person or to know what is bad and good. I left my home at about 11:30 am and it was around 12 noon, and when I saw the accused, the Nala is about 1 kilometer from my house. I saw the accused when I was returning after taking bath. I saw the accused front to front. On the embankment of the Nala, the accused went southern direction after crossing me. It is not a fact that the accused was not in the village on the relevant day of the incident. It is not a fact that I have not seen the accused with blood mark in his wearing apparels and holding a bloodstained tangle, and that I have seen the deceased lying with a bleeding injury. It is not a fact that I am deposing falsely at the instance of PDOL 1. PDOL 4, my lord. Next page 30. I know the accused on PDOL 1 about more than 1 year back. When I returning from my agriculture field, I saw the accused coming with a bloodstained tangia and his wearing apparels was also lost. When I went to the spot, I found the deceased lying dead with a bleeding wound on his head. I was told that the accused assaulted him with the tangia. It is not a fact that the accused was not present in the village on the alleged date of incident. The accused was staying at Borgad and he has also his house in our village. The accused was moving towards Nara side. I completed my fieldwork at around 12 o'clock on the noon. I had been to the land to plow it. It was summer. I saw the accused near the house of the deceased. It is not a fact that I had neither seen the accused nor him seeing him holding a tangia with bloodstain and his appearance with bloodstain. I was not examined by the police. It is not a fact that I am stating falsehood at the instance of PW1.
The weapon, of course, that was not
seized because you are thrown to that Nala. That was not seized.
Who has stated that?
IO has stated.
IO confided. So that was not recovered. It's
Not
all
recovered.
But the doctor has stated that it is possible by axe.
By axe, but axe was not produced for him. The doctor.
That's
It was 7 hours.
And the wearing apparels of the appellant perhaps were also seized, and it was found human blood of B group. These are the weapon. These are the which one is the of the accused? because IO says
Exhibit A, PC कोटा कହାର?
on production of the complainant से कहूची ना था जेतला accused को arrest कला कहूची I arrested the accused in the page 38. I arrested the accused from his house. On the same day, I see the wearing dhoti. अच्छा गोटे धोती जब धोती टा मार्क है MO4 हला से MO4 टा जो धोती टा मार्क है सेटा बोधे जाई छी
page 42 रे अछि मेलर that is dhoti is F
अच्छा धोती F no blood लिखा है अच्छा बट ये जो डिसीज्ड रो ये गुडा करे सब तार लुंगी गामछा से गुडा करे सब ह्यूमन ब्लड ग्रुप अछि एटा so Mr. Panda the plea एटा तो माने गुडे just passive ये टाइप रो सजेशन देइछंती and they have denied and from your side also neither through the evidence of any of the prosecution witnesses nor by examining any defense witness or any doctor that you are being treated for that there is nothing is there. Number two, plea of insanity जदियो आपण जदि नेबे आपण प्रमाण करिवे बा जदि एविडेंस ऑन रेकॉर्ड मध्ये आसीबो ताहले भी कोर्ट कंसीडर करि पारे एठी जहा एविडेंस आसुची अपेलेंट गाली देई जाउथला बैकग्राउंड टू सम एक्सटेंट रहुची मध्ये डिस्प्यूट कारण जमीटा रहिची डिसीज ना रे आर वार्ता ता ना रहिची सी से जमीर सेल डीटा को आउट लोक ना कर देची तापरे गाली देई जाउथला ई आसी ताको मना करची then he has dealt that blow and the impact of the blow as appears from the evidence of this doctor who has conducted post-mortem examination that the depth is 5.5 cm and it was in the midline of the frontoparietal region ଆଉ fracture multiple fractures ହେଇଛି ଗୋଟେ bone ମଧ୍ୟ ଭାଙ୍ଗିକିନି ସେଟା brain materials କୁ ପଶିଛି then hemorrhage ଅଛି subdural intracerebral hemorrhage ଆଉ ଏବଂ the doctor has specifically opined that the injury was sufficient to cause death of a person and it could be possible by the acts. It is not the law that if you give a single blow, it cannot attract the ingredients of offense under section 302. So if that is not there, this is the nature of injury which you have caused on the vital part of the body. And it cannot fall within any of the exceptions. ସେଟା ନୁହେଁ ଯେ ଆପଣଙ୍କର ତାଙ୍କ ଭିତରେ କିଛି କଳି ହଉଥିଲା so ସିଏ ଗାଳି ଦେଇକିନି ଯାଉଥିଲା ଇଏ ତାକୁ ଆସି just ମନା କରିଛି so he was having that weapon ତାପରେ ତାର reaction spot ରେ ଗୋଟେ ଏମିତି ନୁହେଁ ଯେ ଗୋଟେ abnormality ଆପଣ ଯୋଉ plea ଟା ନେଇଛନ୍ତି ମନେ କରନ୍ତୁ ଗୋଟେ କେତେଟା କେସ୍ ରେ ଅଛି ମାରି ଦେଇକିନି ସେଠି ଛିଡା ହେଇଥିବ ପୋକାଙ୍କ ଭଳିଆ ଅନଉଥିବ ଏଇ ଯୋଉ ଇଏ ସେମିତି ତ କିଛି ନାହିଁ rather you took that weapon from the spot and also it could not be traced out. That means either you have concealed or somewhere thrown it. Jabi ho ki save evidence at least apanko gharu seta jabot helani jadu you are tenu ei circumstance re if no exception it is then how do you say that the conviction of the appellant what is your submission by the way?
Only single blow.
No, single blow.
300 to 300 per part. And more than 8 years in custody, he was granted bail.
Single blow on the head, causing this type of injuries without any provocation when the doctor has opined that it is sufficient in ordinary course of nature cause death. ଆପଣ exception ଭିତରକୁ ସିନା ଗଲେ ସିଆଡକୁ ଯିବ ଆପଣ ଯୋଉ ପାଞ୍ଚଟା exception କହିଛି section 300 ରେ ହେଲା ହଁ ପ୍ରଥମେ ଆଗେ ଦରକାର ଆପଣଙ୍କୁ ସେଟା ଆସିବା ଦରକାର 300 ର ଯୋଉ ଚାରିଟା କ୍ଲଜ ଅଛି ଯେ ମର୍ଡର କୋଉଠି ହବ କଲ୍ପେବୁଲ ହୋମିସାଇଡ ତା ଧିରୁ ଗୋଟେ ରହୁଛି sufficient in ordinary course of nature ସେଟା ଏଠି ଅଛି ବାକି ଯୋଉ 5ଟା exception ଅଛି ଆପଣ ଆଣିଲେ ସିନା ତାକୁ not amounting to murder ହେଲେ ତାକୁ 1 କି 2 ଭିତରେ ଆପଣ ଆଣିବେ 304 part 2 ର ବା part 1 ର ଯଦି exception ଭିତରକୁ ନ ଆସିଲା କେମିତି କଣ ଆପଣ ଖାଲି single blow ହେଲେ ହବନି ହଁ single blow ଗୋଟେ non vital part of the body ହେଇଥାନ୍ତା କଣ ହେଇଥାନ୍ତା ଅଲଗା କଥା जो प्रकारे जो पार्ट को देइचंती जो फोर्स रे देइचंती 5 cm गोटे हेड भीतर को पसीवा पसिकिनी ब्रेन को अफेक्ट करिवा से गुडा को सब फ्रैक्चर इट्स नॉट दैट इट्स ए माने with all force it has been given maybe it's a single flow तापर अच्छा गोटे रही जाइथिला बोले ताको आपण बाहर करी कि नैचन ना कोन एई टाइप रो बोले
PW2 has stated.
हां
PW2 has
हां
stated.
की गोटे कहूची तो
PW2 madam.
सेटा स्टिक कर जाइथिला आपण ताको बाहर करनी
Aye.
took out right that is dealt a blow on the head with the tangia accused took out the tangia from the head they said tangia was one so
And 105 of evidence is very clear. If he is claiming for that general exception, bottom lies on him too.
No step has been taken.
किछि
suggestions have
नहीं
been
ना दिया आज ताको तरफ तो किछि स्टेक ना
Only
नाही
suggestions are
Only
किंबा सर्कमस्टांस एमती किछि नाही
Aye.
जे कोर्ट गोटे
inference
इन्फरेन्स ड्र करिवो जे नाही गोटे लोकटार बोधे मानसिक अवस्था बा माने अच्छा प्ली ऑफ इंसानिटी माने एट दैट पर्टिकुलर पॉइंट ऑफ टाइम दैट इज रेलेवेंट गोटे लोक हुए तो अबनॉर्मल थाई पारे किंतु द लॉ रिक्वायर्स दे सेही समय रे तार येटा माने को टाइप रो रहउची सो दैट इज रेलेवेंट इट्स नॉट दैट इट मार पेनल कोड दियो कहि दियो और section 84
section 84
and এটা গোটে ইতিহাস এন্টার টি করা যায় କୁହନ୍ତୁ ଆପଣ କ୍ଲାଏଣ୍ଟ ଲେଖ ସିଙ୍ଗଲ ବ୍ଲୋ attract
ଆଉ ଗୋଟେ ହେଲା
ଆଜ୍ଞା
ଯେ ପ୍ରିମେଡିଟେସନ ଯଦି ନାହିଁ ବୋଲି କହି ପାରିଥାନ୍ତା ପ୍ରୋଭାଇଡେଡ ସେ ସେଇ ଗାଁରେ ଥାନ୍ତା ସେଇ ଗାଁରେ ଥାଇକିରି ଏକ୍ସଟ୍ରା ଧରିକି ଯାଉଥାନ୍ତା ହେଲେ ନର୍ମାଲି ଭିଲେଜ ପିପୁଲ କ୍ୟାନ୍ କ୍ୟାରି କିନ୍ତୁ ଏଇଟା ସେ ବରଗଡରୁ ଆସୁଛି
ଏଇଟା
ବରଗଡ଼ରୁ sometimes comes
ଯୋଉଦିନ ଘଟଣା ହେଲା ସେଦିନ
ବରଗଡ଼ରୁ ଆସିছে sometimes he comes and scolds somebody that is the evidence ଯେତେବେଳେ ଆସୁଛି କାହା ଗୋଟେ ଗାଳି କରୁଛି must be insane କିନ୍ତୁ
see this decision Mahesh Valmiki versus State of MP 2000 volume 1 SCC 319
I may pardon 2000
volume 2000 volume 1 SCC 319
319
319 319
पार्टी ना आगे
Mahesh Valmiki versus State of MP. That there it has been held, there is no principle that in all cases of single blow, section 302 of the Indian Penal Code is not attracted. A single blow may, in some cases, entail conviction under section 302 of the Indian Penal Code. In some cases under section 304 and in some cases 326. The question with regard to the nature of offense has to be determined on the facts and circumstance of the case. The nature of injury, whether it is on the vital or non-vital part of the body, the weapon used, the circumstances in which the injury is caused, the manner in which the injury is inflicted are all relevant factors which may go to determine the required intention or knowledge of the offender and the offense committed by him. In the instant case, a single blow, then another decision that is also a case of that is reported in 1993, AR 93, Supreme Court 1487. AR 93, Supreme Court 1487, Palaru versus State of MP. The observation is like this takes us to the nature of offense. All the three eyewitnesses have spoken that the appellant dealt only one blow with the agricultural implement. Having regard to the time and the surrounding circumstances, it is difficult to hold that the caused the death of the deceased, particularly if he was not armed with any deadly weapon as such. As it occurred in 304 part 2.
It is deadly weapon.
While it is true that there was only one blow, but the medical evidence on record definitely indicate the severity of the blow was such that it was sufficient for causing death. Then they took into account so and so, and ultimately it held that it definitely indicates the intention to cause and thereby cause death. Then another decision is okay, this is 2010, I would have 2010 9 SCC 799. The question whether a blow on the skull of the deceased with a crowbar would attract section 302 held thus. In our opinion, as nobody can enter the mind of the accused, his intention has to be gathered from the weapon used, the part of the body chosen for the assault, the nature of injury caused. Here the appellant had chosen a crowbar as the weapon of offense. He had chosen the vital part of the body, that is the head, for causing the injury, which has caused multiple fractures of the skull. This clearly shows the force with which the appellant has used the weapon. The cumulative effect of all these factors irresistibly leads to one and only one conclusion, that the appellant intended to cause the death of the deceased. Another decision that is there in 2013 14 SCC 246. Whether a single blow on the skull with a darat would attract the conviction under section 302. From the statement of the doctor, the nature of injury caused to the deceased has been brought out. A perusal thereof would leave no room to doubt that the appellant had chosen the sharp side of the darat and not the blunt side. The ferocity with which the aforesaid blow was struck clearly emerges from the fact that the blow resulted in cutting through the skull of the deceased, caused a hole therein, exposing the brain tissue. When a blow with a deadly weapon is struck with ferocity, it is apparent that the appellant intends to cause bodily injury of a nature which he knows it so imminently dangerous that it must in all probability cause death. Then
pardon, 2013
this
14.
is
14 SCC page.
no, no,
2013 volume 14.
page
page होची 246 है ना Somraj versus state of HP, Himachal Pradesh. Okay. Then
ଏସବୁ ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ
ସବୁ ବିରୁଦ୍ଧ
keeping ଏଇଟା ହଉଛି ଦେଖନ୍ତୁ ଏଇ କେସ୍ ରେ ତାର conclusion ଆସିଲା ସେଇ ଯୋଉ decision keeping in view the parameters of the judgment referred to by the so and so, we have no doubt in our mind the appellant must be deemed to have committed culpable homicide amounting to murder under section 302 of the Indian Penal Code, as he had struck a darat blow with the intention of causing such bodily injury which he knew so imminently dangerous that it would in all probability cause the death of. अच्छा এই কেস রে কোন ହେଇଛି ଯୋଉ କେସଟା ଆମେ ସୁପ୍ରିମ କୋର୍ଟ ର ସେଠି 302 ରେ ଟ୍ରାଏଲ କୋର୍ଟ କନଭିକ୍ସନ କରିଥିଲା ହାଇ କୋର୍ଟ ତାକୁ ମୋଷ୍ଟ ଲାଇକଲି ଜଷ୍ଟିସ ଚନ୍ଦ୍ରଚୂଡଙ୍କର ଡିସିସନ ଏଇଟା ହଉଛି ତାକୁ 304 ପାର୍ଟ 2 କରିଦେଇଥିଲେ and after going through this ତାର factual scenario ହଉଛି जे while he was passing near by the hand pump near the house of so and so, the लोक आसिले case of the prosecution, respondent inflicted an axe injury on the skull of the deceased, which was the cause of the death. है cause of death मतलब डॉक्टर कहला या क्रॉस इंजुरी so and so गला ସେଇଟାକୁ ସିଏ रिस्टोर कले जो कन्विक्शन टा ट्रायल कोर्ट करथिला conclusion which we allow the appeal while setting aside the judgment of the High Court, restore the conviction and of the respondent by the trial court under section 302 of the Indian Penal Code. Respondent is sentenced to suffer imprisonment for life. Respondent shall forthwith surrender to his sentence a copy of so and so. So what we say that the submission which you made that it is a case of single blow ताकू 304 part 1 की part 2 कर दियंतु it is not because of we have to first come to either that it is culpable homicide not amounting to murder ता हेले जाएंगे 304 आसीबो अदरवाइज चांस नाही आउ गोटे सर्कमस्टांस जदी से क्लॉज गुडा को जदी अट्रैक्ट हो तेणु एठी व्हाट इट हैज बीन स्टेटेड को वेपन रे आपण मारुचंती बॉडी रो को पार्ट को आपण मारुचंती को फोर्स देकिन मारुचंती ये सब को मध्य कंसीडर करिया पड़ियो तेणु एठी शार्प साइड यूज करचंती टांगिया रे मुंडो को मारिचंती तार इंपैक्ट फ्रैक्चर होची ब्रेन मटेरियल अफेक्टेड एवं 5 केते मीटर भीतर को पसी 5 सेंटीमीटर एवं से गोटे बोन टा मध्य ताकू अफेक्ट करची एवं injury specific opinion is that injury is sufficient in ordinary course of nature. आउ important होची आपण जो plea टी नहीं जानती
किसी एविडेंस नाही
तार किछि ना prosecution evidence रो किछि आमे पाइबु जे he was not in a either on a state of
unsound mind or anything.
Sound of mind and whether आपण को तरफ रो किछि evidence नाही तेणु एठी how the conviction will be altered to particularly when these eyewitnesses person two eyewitnesses version are consistent nothing has been elicited in the cross examination nothing
ଟିକେ ଏକ୍ସାମିନର
ଏଟା କଣ ପ୍ରାଇଭେଟ ଡିଫେନ୍ସ ଥିଲେ
ସେଟା ଖାଲି ଆଡଭୋକେଟ ଅଛି କିନ୍ତୁ ସେଟା ହେଇଥିଲେ ତ ଆଉ ଗୋଟେ ଆସନ୍ତା ଲିଗାଲ ଏଡ୍ ରୁ ଏନଗେଜ କରା ହେଇଛି ମାନେ ନିଶ୍ଚୟ ମଷ୍ଟ ବି ପୁଅର ସଫିସିଏଣ୍ଟ ଆଜ୍ଞା
ଲିଗାଲ ଏଡ୍ ଦେଇଛନ୍ତି
ହଁ ମତେ ଲିଗାଲ ଏଡ୍ ଦେଇଛନ୍ତି ସେଠି
ମାନେ ଆପଣଙ୍କୁ ନାହିଁ
ସେଠି ଆଜ୍ଞା ଖାଲି ଆଡଭୋକେଟ ନା ଲେଖା ହେଇଛି ଲିଗାଲ ଏଡ୍ କଥା କିଛି ଲେଖା
ତାହେଲେ ପ୍ରାଇଭେଟ
ଆଜ୍ଞା
ଏଥିରେ ଏସଡିସି ଅର୍ଡିନାରଲି ଲେଖା ହେଇଥାନ୍ତା
ଲେଖା ହେଇନି କିଛି ଖାଲି ଆଡଭୋକେଟର ନାଁ ଲେଖା ହେଇଛି ଆଜ୍ଞା
এবি ବାରିକ ଇଏ ଦେଖି ଦଉନାହାନ୍ତି ଅର୍ଡର ସିଟ୍ ଜଣା ପଡିଯିବ ଟ୍ରାଏଲ କୋର୍ଟ ର ଅର୍ଡର ସିଟ୍ ହଁ ସେଗୁଡା ଦେଖ
ଏଜ୍ ଫ୍ୟାକ୍ଟର ମୋର ଦେନ୍ 80 ହେଇଥିବ
ଶୁଣୁ ଆପଣ ସିନା କୌଣସି ତା ଭିତରକୁ ଆସିଲେ ଏଜ୍ ଫ୍ୟାକ୍ଟର ଆମେ ଯଦି ତାକୁ ଅଲ୍ଟର କରିଥାନ୍ତୁ आपनर एज फैक्टर नहीं कि आपण 8-9 वर्ष गलेनी दे पीरियड अंडरगोन की कोन दैट्स ए डिफरेंट मैटर बट व्हेन इट इज 302 तो दीटा तो पनिशमेंट अवतार प्रश्न को उठुची तेणु एटा रेयरेस्ट ऑफ रेयर केस न होई कि एटा 302 रे
minimum
लाइफ
punishment.
मिनिमम पनिशमेंट दिया है
SDC नुह ये प्राइवेट
एसटीज लिखा है
everybody private
इस लिखा है नॉर्मली जजमेंट स्टेट डिफेंस इतने लिखा है था
language la 84 nothing is an offense which is done by a person who at the time of doing it by reason of unsoundness of mind is incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to law. The settled position of law is that every man is presumed to be sane and to possess a sufficient degree of reason to be responsible for his acts unless the contrary is proved. This section provides that a man who is by reason of unsoundness of mind prevented from controlling his own conduct and deprived of a power of passing a rational judgment on the moral character of the act he meant to do cannot be legally responsible for the act. A man who by reason of mental disease is prevented from controlling his own conduct and a man who is deprived by disease affecting the mind of the power of passing a rational judgment so and so is entitled to benefit under this section. Under this section, an accused is protected not only when on account of insanity he was incapable of knowing the nature of the act, but also when he did not know either that act was wrong or that it was contrary to law, although he might know the nature of the act itself. He is, however, not protected if he knows what he was doing was wrong, and even if he did not know that it was contrary to law, and also if he knew that what is he doing was contrary to law, it was wrong. Okay. The burden to prove that the accused was of unsound mind and as a result thereof he was incapable of knowing the nature and consequence of his act is on the accused. Section 84 is one of the provisions under chapter 4 of CPC which deals with general protection. This section provides that nothing is an offense so and so. The burden of proving the existence of circumstances bringing the case within the purview of section 84 lies on the accused under section 105 of the Evidence Act. Every type of insanity is not legal insanity. The cognitive faculty must be so destroyed as to render one incapable of knowing the nature of his act, or that what is doing is wrong or contrary to law. The court shall presume the absence of such insanity. The burden of proof of legal insanity is on the accused, though it is not as heavy as in the prosecution to prove the offense. The court must consider whether the accused suffered from legal insanity at the time when the offense was committed.
Yes.
In reaching such a conclusion, the circumstances which preceded, attended, and followed the crime are relevant consideration. The prosecution, in discharging its burden in the face of plea of legal insanity, has merely to prove the basic facts and rely upon the normal presumption of law that everyone knows the law and natural consequence of his act. There is a good deal of difference between medical insanity and legal insanity, and the courts are concerned only with legal and not the medical aspect of the matter. It is not every kind of frantic humor or something unaccountable in a man's action that points him to be a madman, to be accepted from punishment. It is not mere so and so would suffice the plea of insanity. Abnormality of mind is not by itself sufficient to show that the accused must have acted while of unsound mind. Such exemption can be claimed only when the insane person is incapable of knowing the nature of act, or he is doing either wrong or contrary to law. Epileptic fits, abnormal behavior, or queer behavior is not sufficient to attract the application of Section 84. There are four kinds of persons who may be said to be not of sound mind. One is an idiot, one made non-campus by illness, then a madman, then a drunkard, who is one who is drunk. Then they have distinguished how it is. At the time of doing it, to establish the defense on the ground of insanity, it must clearly be proved that at the time of committing the act, the party accused was laboring under such defect of reason from disease of the mind as not to know the nature and quality of the act he is doing. Or if he did know it, that he did not know he was doing what was wrong or contrary to law. The crucial point of time at which unsoundness of mind should be established is the time when the crime is actually committed. The mere fact that on former occasion the accused had been occasionally subject to insane delusions, or had suffered from derangement of the mind, or that subsequently he had at times behaved like a mentally deficient person, is per se insufficient to bring his case within the exemption. In order to ascertain whether the accused was insane at the time of commission of offense, it may be relevant to consider the state of such person's mind immediately preceding as well as subsequent to the commission of the offense. ତେଣୁ ଏ କେସରେ ଆପଣ ଯଦି appellant what he was doing that he was making ho halla in front of the house, ତେଣୁ the conduct of the deceased ଆପଣ କହିଥାନ୍ତେ deceased ଯଦି ଚୁପଚାପ ରହିଯାଇଥାନ୍ତା ଆସି ନଥାନ୍ତା ତାହେଲେ ଘଟଣା ତ ହେଇନଥାନ୍ତା। ତେଣୁ ସିଏ ଆସିକି ତାକୁ ମନା କଲା କଣ ପାଇଁ, ମନା କଲାରୁ ଇଏ ହୁଏତ ପ୍ରୋଭୋକ୍ ଦେଇଥିନି ମାରି ଦେଇଥିବ। ବଟ୍ ଇଟ୍ ଇଜ ଭେରି ନ୍ୟାଚୁରାଲ, ଆପଣ ଆସି ଜଣକ ଘର ସାମ୍ନାରେ ପାଟିତୁଣ୍ଡ କରିବେ, ଗାଳି ଫଜିତ କରିବେ, ସେ ଲୋକ ମନା ହିଁ କରିବେ ଯେ କାହିଁ ତମେ ପାଟି କରୁଛ। ତାପରେ ଯୋଉ ଆପଣଙ୍କର what you have done thereafter, so you cannot say that merely he came and asked you to refrain from your activities, that doesn't mean that he has provoked it. Hala? You went to the house with a tangia, abused in front of the house, okay? So as a normal person, he came and said that don't do it here. Then this is your act. So yes, Mr. Tripathi, what do you say?
Yes, my lord. Intention was there, my lord, because he came with a tangia from Bargad and came to the house of the deceased. And second thing, my lord, that so far the insanity part is concerned, no evidence is there. The section 105 is very clear. If he is claiming, then burden lies on him. But he has not proved that except few suggestion to the prosecution witnesses, my lord. And motive part is which is not necessary, but my lord, still then there is a land dispute between them.
105 ର illustration A ରେ କୁହାଉଛି, accused of murder alleges that by reason of unsoundness mind he did not know the nature of the act. The burden of proof is on A. But decision that ଏଇଟା ମାନେ ସେମିତି ନୁହେଁ, burden ମାନେ ଯୋଉ beyond
general exception
probability ଆପଣଙ୍କୁ ଯେମିତି ଆପଣଙ୍କର defense plea ଯେମିତି ପ୍ରମାଣ ହୁଏ preponderance of probability ସେଇଟାକୁ establish କରିବ। But ଏଠି ତ କିଛି ନାହିଁ।
A doubt is only to be created, that's all. Here the court, out of curiosity, has taken something that could it be like this, could it be like that, and found despite all this no ingredients of 84.
84 ଉପରେ ମୁଁ ଟିକେ ଆଉ ଟିକେ ରିସର୍ଚ୍ଚ କରିବି।
ରିସର୍ଚ୍ଚ ଆଉ କଣ କରିବେ
ଆପଣ ଏଗେନଷ୍ଟ ରେ କିଛି
ଟାଇମ ଆପଣ ଶୁଣନ୍ତୁ,
ଆପଣ ପ୍ଲି ନେଇଥିଲେ ସିନା କରିଥାନ୍ତେ,
କିଛି ନାହିଁ।
ଯୋଉ କେସ୍ ରୁ କିଛି
we are trying from our side whether that could be taken at all, but there is absolutely nothing except some suggestions. You have no
ମେଡିକାଲ ଏଭିଡେନ୍ସ ନହେଲେ ବି ନେବର ଦି ଚାରି ଜଣଙ୍କୁ ଏକ୍ସାମିନ କରିଥାନ୍ତେ, ସେ ଏମିତି ପାଗଳ ଭଳିଆ ହଉଥିଲା।
କିଛି ନାହିଁ, ମେଡିକାଲ ଡକୁମେଣ୍ଟ ନାହିଁ, କିଛି
ମେଡିକାଲ ନହେଲେ ବି
just before that, before the incident, what was your mental state is not there.
ସେଇ କେ ଗୋଟେ ଏଭିଡେନ୍ସ ଦେଇଥିଲେ ହେଇଥାନ୍ତା।
କିଛି ନାହିଁ ଯୋଉଥିରେ ମାନେ apart from the fact, ଆଚ୍ଛା ଏଠି ଆପଣ ନିଜ ମାନେ କାଉନସିଲ କୁ ଏନଗେଜ କରିଛନ୍ତି, ଇଟ୍ସ ନଟ୍ ଏ ଆପଣ ନିଜେ ଏନଗେଜ କଲେ। ତାପରେ ଏଇ କେସ୍ କୁ ଯଦି ମାନେ ଇଏ ନ ଭାଙ୍ଗିଲା, ଜେରାରେ ନ ଭାଙ୍ଗିଲା, ଆପଣ କିଛି ତ ସେଇଟାକୁ ଟିକେ ଷ୍ଟ୍ରେଚ୍ କରିପାରିଥାନ୍ତେ, ମାନେ ଏକ୍ସେପସନ 4 କୁ ଆଣିବାକୁ, ଯେ ସିଏ ଆସିଲା ତାପରେ ସିଏ ତାକୁ କଣ କହିଲା, ଏଇଆ ହେଲା କହିଲା, ତାପରେ ସିଏ କଣ ମାନେ ଷ୍ଟ୍ରେଚ୍ କରିକି କିଛି ଗୋଟେ ମ୍ୟାଟେରିଆଲ ଆଣିଥାନ୍ତେ। ତ ଏମିତି କିଛି ସମୟ ଚାଲିଲା, ତାପରେ ତ ଯୋଉ କେସରେ କିଛି ନଥାଏ, ଯେଗୁଡାକ ଆଇ ୱିଟନେସ କୁ ଭାଙ୍ଗି ହବନି, ସିଙ୍ଗଲ ବ୍ଲୋ ଅଛି, ତାକୁ ଆଣିବାକୁ କିଛି ଜିନିଷ ମାନେ ଲିଡିଂ କରାଯାଏ କ୍ୱେଶ୍ଚିନ୍। ତ ଇୟା ତ ହେଇଥିବ, ତାପରେ ତ ଯଦି ଟ୍ରାକ୍ କରିଗଲା ଧରିନେଲା ଗୋଟେ ଇଏ, ତେଣୁ ବହୁତ ସମୟରେ ହୁଏ ସେମିତି। ତାପରେ ସିଜର ୱିଟନେସ ମଧ୍ୟ ପାଖାପାଖି ଘର ପାଖାପାଖି ଲୋକ ଥିଲେ, ଏଇ ତାଙ୍କ ଭିତରୁ ବହୁତ ପାଟିତୁଣ୍ଡ ଶୁଣିଲ ତମେ, ଇଏ ତାପରେ ଗଲା ବେଳକୁ ତାକୁ ସିଏ ଅନ୍ୟ ପଏଣ୍ଟରେ ଦେଇଥିବ, ତମେ ତାକୁ ଆଣିକିନି ପୁରେଇ ଦବ ତମର ଇଏରେ। These are the tricks, art of bringing in something, but nothing has been done.
My lord was
ଏଠି ତ
cross-examining.
ଓଲଟା post occurrence witness ମାନେ ଆଉ ଟିକେ ଗୋଟେ circumstance କହୁଥିଲେ।
ସେ ଦେଖିକି ଯାଉଥିଲା। In one case, my lord has brought on record.
Oh, leave it.
It's only the cases in this post. Here was the root that he
ସବୁଗୁଡା ପଳେଇ ଆସିଲେ ବୋଧେ।
And so far, my lord, the weapon offense which was not seized, in that fight, I have got a
Give
decision
it.
that where eyewitnesses are there, the production of weapon
it's not him.
is not signed by me. That is the
All right, please take your seat. JCRLA number 49 of 2008. The appellant Lajara Kshatriya faced trial in the court of London Additional Session Judge cum Special Judge Vigilance Balangir in Sessions case number 104/9 of 2006-07 for offense punishable under section 302 of the Indian Penal Code on the accusation that on 24/3/2006 at 11:30 a.m. at village Sujia, he committed murder by intentionally causing death of Sudhakar Kshatriya, bracketary hereafter the deceased. The London Trial Court by impugned judgment and order dated 5/4/2008 found the appellant guilty of the offense charged and sentenced him to undergo imprisonment for life and to pay a fine of rupees 10,000, in default to undergo RI for 2 years. The prosecution case, as per the first information report lodged by Rajendra Kshatriya, bracketary PW1, before the inspector in charge of Luisinga police station, officer in charge, on 24/3/2006 is that on that day at about 1 p.m. He was informed by
His nephew.
Roshan Suna, bracketary PW6, that the deceased had been assaulted by the appellant with a tangia on his head, for which is lying with bleeding injuries. Receiving such message from PW6, PW1 rushed to his village and found the deceased was lying in an injured condition, having sustained injury on the head by a sharp cutting weapon. The informant PW1 also came to know from his wife and others that while his while the deceased, who was his father, was had been to take his bath at about 11:30 a.m. The appellant assaulted him on his head with a tangia.
Lying in
And he was lying in a
marital
marble condition. the deceased was shifted to the hospital in a vehicle where the doctor declared him dead. Basing on the written report of PW1, which was scribed by the nephew of PW1, namely Vijay Kumar Tandi, PW8, the OIC of Loisinga Police Station, registered Loisinga PS case number 45, dated 24/3/2006 under section 302 of the Indian Penal Code against the appellant. After registration of the case, he examined the informant and other witnesses and then proceeded to the hospital where he found the dead body of the deceased. He held inquest over the dead body, prepared the inquest report by the Exhibit 2, and then issued requisition for post-mortem examination of the deceased. PW 7, Dr. Sucheta Pani of DHS Balangir conducted post-mortem examination over the dead body of the deceased on 25/3/2006 and submitted his report by the Exhibit 6. The PW8 then visited the spot and prepared the spot map Exhibit 7. He also collected the bloodstain earth and sample earth from the spot as per seizure list Exhibit 5, and seized the wearing apparels of the deceased as per seizure list Exhibit 8. The appellant was arrested on 1/4/2006 from his house at rail station Para Bargad, and his dhoti was also seized as per seizure list Exhibit 9. The appellant was sent for his medical examination and collection of his nail clippings and hand wash, and the same was also seized by the IO as per seizure list Exhibit 10. The RI was on the requisition of the IO, the local RI prepared the sketch map Exhibit 11, and one seal deed being produced by PW1 in respect to a land transaction by the accused in favor of one Subhakar Chhatri. Even though the land ROR stood in the name of the deceased, was seized as per seizure list Exhibit 3. The wearing apparels of the accused as well as the deceased were sent to RFSL Sambalpur for chemical examination and opinion through court. And the chemical examination report was received subsequently and by the Exhibit 13. And on completion of investigation, charge sheet has been submitted. under section 302 of the Indian Penal Code against the appellant. The defense plea is one of denial. In order to prove its case, the prosecution examined so and so exhibit. The London trial court, after assessing the oral as well as documentary evidence, came to hold that the deceased met a homicidal death, having sustained an incised wound over his parietal region, being hit by a heavy sharp cutting weapon like axe, and the injury was sufficient in ordinary course of nature to cause death of the deceased. The London trial court, after discussing the evidence of two eyewitnesses, that is PW2 and PW6, came to hold that from the testimony of PW2, it can be inferred that she would not be in a position to observe the assault part of the incident, since, as per her version, the incident took place on the lane adjoining to their house, and she rushed to the lane, hearing the scream of her father-in-law bracketed deceased. However, from her evidence, it is forthcoming that she saw the appellant dragging the tangia, which pierced on the head of the deceased. The London trial court, however, accepted the evidence of PW6 in toto and held that the evidence of from the evidence of these two witnesses, it can be safely accepted that it was none else than the appellant who dealt the fatal blow on the head of the deceased. The London trial court also accepted the version of PW3 and 4, who have stated to have seen the appellant walking towards Usmel Nala holding a bloodstained tangia. It was further held that the non-seizure of the weapon of offense cannot demolish the entire evidence of the adduced by PW2, 3, 4, and 6. And if the evidence of these four witnesses coupled with the medical evidence is taken into account, then an irresistible conclusion can be drawn that it was the appellant who dealt fatal tangia blow to the head of the deceased, as a result of which he died instantaneously. The London trial court also considered the plea of insanity taken by the defense and came to hold that those suggestions have been given to PW1, PW3, and PW6 in that respect, but they have denied the suggestion, and it is apparent from the evidence of the PWs that after piercing the tangia on the head of the deceased, the appellant dragged and removed the same and left the spot, and he escaped from the occurrence village after the incident. And that he threw the weapon of offense somewhere for which it could not be traced. And that there is no decisive circumstance in favor of the appellant to show that he lost his cognitive faculty to a decree prescribed in section 84 of the Indian Penal Code. And therefore, the burden of proof on the appellant has not, to his insanity, has not been discharged. Ultimately, the Lenine trial court held that the prosecution has proved its case against the appellant beyond all reasonable doubt and found the appellant guilty under section 302 of the Indian Penal Code. Before going to assess the evidence of the two eyewitnesses, that is PW2 and PW6, let us analyze the evidence regarding of the prosecution as to whether the prosecution has established that the deceased met with a homicidal death. Apart from the inquest report, which has been prepared by PW8, where the injury has been mentioned, nature of injury has been mentioned, it appears from the evidence of PW7, the doctor, that he noticed injury. Then he has further opined that the death was due to injury to the brain, and time of death is within 36 hours prior to the PM. The injury was sufficient to cause death of the person. Injury could be possible from the acts, and he has proved his report Exhibit 6. Nothing has been elicited in the cross-examination to disbelieve the evidence of PW. The Lenine counsel for the appellant has also not challenged the homicidal death aspect of the case. After going through the evidence on record, particularly the evidence of PW7 and the postmortem report Exhibit 6, we are of the view that the Lenine trial court has rightly came to the conclusion that the deceased met with a homicidal death. Next para, the evidence of PW2, who is the daughter-in-law of the deceased and wife of the informant bracket PW1, indicates that on 24/3/2006, around 11:30 a.m., the appellant started making ho-halla in front of her house and abused them, and the deceased at that time was moving to the village tank to take his bath, and so he forbade the appellant from making any noise, but the appellant was holding a tangia, dealt a blow on his head with that tangia. The deceased raised scream, "Marigali, Marigali," and hearing such screaming, PW2 rushed to the lane and found the appellant taking out the tangia from the head of the deceased and leaving the place with such tangia, whereas the deceased was lying on the road with bleeding cut injury on the head. The PW2 also raised holla, for which other neighbors rushed to the spot. She further stated that PW6, who was her nephew, was sent to inform PW1. And after arrival of PW1, the deceased was shifted to the hospital in a vehicle. Though suggestion was given to the PW2 that the accused was mentally deranged, but he has denied this suggestion. And however, he stated that the accused was acting like a mad person. Nothing further has been elicited in the cross-examination of PW2 to disbelieve her evidence. The London trial court has rightly found that even though she might not have seen the actual assault on the deceased, but immediately after hearing the screaming of the deceased, she reached at the scene of occurrence and found the presence of the appellant at the spot, was taking out the tangia from the head of the deceased and leaving the place with the tangia. The evidence of PW2 has been rightly accepted by the London trial court. Coming to the evidence of PW6, who is the grandson of the deceased, he has stated that at the time of occurrence, he was sitting on the veranda of one S.K.SAHOO after returning from his college and saw that the appellant was moving towards their house, brandishing an axe and uttering obscene words. The deceased came out of the house and seeing the appellant, the appellant dealt a tangia blow on his head, for which the deceased collapsed on the ground. The witness further stated that the axe was pierced on the head portion of the deceased and left affixed, and the appellant dragged the same from the deceased head and left the spot with the tangia. He further stated to have given information to PW1 and then proceeded to Luisinga to arrange a vehicle to shift the deceased to hospital. In the cross-examination, it is he has stated that the accused was staying in Burger town, and though he was not an inhabitant of Sujia village, but he was coming to that village sometimes, and he has denied the suggestion given by the London Defense Counsel that the appellant was a mentally derailed person, and on that day also he was mentally derailed. The witness further stated that whenever he was coming to village Sujia, he used to rebuke someone, and on the occurrence day, the appellant was rebuking the deceased and another person while he was moving towards their house. Nothing has been elicited further in the cross-examination to create doubt on the version of PW6. Therefore, from the evidence of the two witnesses, that is PW2 and PW6, it is apparent that it is the appellant who dealt a blow with a tangia on the head of the deceased, for which the deceased sustained bleeding injuries. The other two witnesses who are who stated to have seen the appellant with the with a tangia, bloodstained tangia on that day, are PW3 and PW4. PW3 has stated that on 24/3/2006, around 11:30 to 12 noon, while he was about to take bath at Kusumel Nala, he found the appellant passing by that side, wearing a bloodstained banyan, and he was also holding a tangia with bloodstain. The London Defense Counsel gave a suggestion to PW3 that the appellant was mentally derailed at the time of occurrence, and he was mad 10 years prior to the occurrence, but that suggestion has been denied by PW3. The other witness, that is PW4, has also stated that while he was returning from the agriculture field, he saw the appellant coming with a bloodstained tangia, and his wearing apparels were also bloodstained. And when he went to the spot, he found the deceased was lying dead with a bleeding wound on his head. This evidence is akin to the evidence of PW3, and nothing has been elicited in the cross-examination. The learned counsel for the appellant submitted that since the deceased forbade the appellant from shouting while he was armed with a weapon, he was provoked and dealt a single blow on the head of the deceased, and therefore it may be at best be a case under section 304 part 1 of the Indian Penal Code and not 302 of IPC. The learned counsel submitted that even though the defense has not proved the unsoundness of mind of the appellant at the relevant point of time, but the witnesses have denied in that respect. If this court finds that there are material on record to that effect, the same can be considered. The learned counsel further argued that since the appellant has remained in custody, judicial custody, for about 8 years, the conviction may be altered to one under Section 304, Part 1 of the Indian Penal Code, and the sentence be reduced to period already undergone. So I would line like this, that the weapon of offense has also not been seized. The Mr. Tripathi Lanen, counsel for the state, on the other hand, argued that when the evidence of the two star witnesses on behalf of the prosecution, that is PW2 and PW8, has remained unchallenged. PW6. Sorry, PW6 has remained unchallenged, and it gets corroboration from the medical evidence adduced by PW7. It can be said that the prosecution has satisfactorily proved that the appellant is the author of the causing the death of the deceased. It is further argued that the postmortem report, the evidence of the doctor, so also the postmortem report, clearly indicates the impact of the blow on the vital part of the body of the deceased, that is head. And the doctor has specifically stated that the injury was sufficient to cause death of the person. And the act of the accused act of the appellant doesn't come within any of the exceptions as enumerated under Section 300 of the Indian Penal Code. And therefore, the contention of the London Council that the conviction to be altered to one under Section 304, Part 1 of the Indian Penal Code is not acceptable. He submitted that merely because a single blow has been given to the deceased by the appellant, that would not ipso facto bring the case within the purview of a lesser offense, particularly in view of the evidence adduced by the doctor and the post-mortem report finding. The London Council further argued that the evidence of these two eyewitnesses get corroboration also from the evidence of PW3 and PW6, four, who have stated to have seen the appellant living with a bloodstained tangia. He argued that even though the tangia has not been seized by the investigating officer, but that cannot be a ground to disbelieve the prosecution case, and in that respect, he has relied upon the decision of so and so, Juta Deichandi. The Land Council further argued that even though if an attempt has been made by the London Defense Council to suggest three of the witnesses that the appellant was suffering, no, the appellant was mentally derailed at the time of occurrence. But all these witnesses have denied such suggestion, and moreover, neither from the prosecution evidence by way of cross-examining the prosecution witnesses, nor by adducing any defense evidence or any medical evidence, it has been proved that the appellant was of unsound mind, and since the burden of proof lies on the appellant to that by reason of unsoundness of mind, he did not know the nature of the act in view of Section 105, illustration A, and the same has not been discharged by the appellant. The London Trial Court has rightly not placed any reliance on such evidence, has not given any importance to such aspect, and therefore the impugned judgment and order of conviction should be upheld and the appeal be dismissed. Coming to the let a discussion the evidence of the eyewitness. No, I'm discussing the now postmortem report finding the discussion. Okay. Now coming to the evidence of the two eyewitnesses. All right. The in the case of back color. In the case of Mahesh Balmiki versus State of MP, reported in 2000 bracket with a river bracket Baharela 1 Supreme Court cases 309. The Honorable Supreme Court, while deciding the question whether a single blow with a knife on the chest of the deceased would attract Section 302 of the Indian Penal Code, held as follows. We quote the relevant portion from paragraph number 9. Hala? Then in case of
Dheeraj bhai.
Yeah, sure, later. 93 अच्छा from Chandra would attract one. In case of 93 Supreme Court 102. In case of Palaru versus State of MP, reported in AR 93 Supreme Court 1487. It was held wherein there was only one blow given by the appellant, and the medical evidence indicated that the severity blow was such that it was sufficient to cause death. It was held as follows. That would the single blow. In case of Singa SINGA PA Singapagu Andia versus State of Andhra Pradesh, reported in 2010. Volume is 9, Supreme Court cases 799. While deciding the question whether a blow on the skull of the deceased with a crowbar would attract Section 302 of the Indian Penal Code, it was held paragraph 16 तक quote करिए. In case of Somraj versus State of Himachal Pradesh, reported in 2013, bracket with a river, bracket by 14 Supreme Court cases 246. While deciding the question whether a single blow on the skull with a darat, DARAT, would attract the conviction under Section 302 of the Indian Penal Code, the Honorable Supreme Court held 16.2 to 16.7 पर्यंत कोट कर दो. In the case of State of Rajasthan versus Leela Ram, reported in 2019 bracket with bracket bahare 13 Supreme Court cases 131, where a single blow was given by the respondent with an axe on the skull of the deceased, which caused his death, and the Lennon trial court convicted the respondent under Section 302 of the Indian Penal Code, but a division bench of the High Court of Rajasthan altered the conviction to one under Section 304 Part 2 of the Indian Penal Code, which was challenged in the Supreme Court by the state, after taking into account the aforesaid decisions, the court held that the judgment of the High Court is manifestly perverse, and the same was set aside, and the conviction of the respondent passed by the London Trial Court under Section 302 of the Indian Penal Code was restored. After going through the evidence of the two eyewitnesses, that is PW2 and PW6, coupled with the evidence of the doctor bracket ray PW7, so also the corroborating evidence of PW3 and PW4, we are of the humble view that the prosecution has satisfactorily proved that it is the appellant who dealt that blow who dealt a single blow on the head of the deceased, which resulted in his death, and the injury was sufficient to cause death. And since the defense has failed to bring the case within any of the exceptions as provided under Section 300 of the Indian Penal Code, we find there is no infirmity and in the impugned judgment. Acha, CJUTA eta kutige mention kar do jo seizure weapon, though it was contended by the London Council for the appellant that the weapon of offense has not been seized, but in the case of Swanso, eta ko paragraph re achi Mr. Para 7 re achi. Wherein it is held that recovery of the weapon used in the commission of the offense is not a sine qua non to convict the accused. If there is direct evidence in the form of eyewitness, even in the absence of recovery of weapon, the accused can be convicted. Acha, say gote paragraph so far as the plea of insanity is concerned. Section 84 of the Indian Penal Code states that which deals with act of a person of unsound mind states that nothing is an offense which is done by a person who, at the time of doing it, by reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. The settled position of law is that every man is presumed to be sane and to possess a sufficient degree of reason to be responsible for his acts unless the contrary is proved. The section provides that a man who is, by reason of unsoundness of mind, prevented from controlling his own conduct and deprived of the power of passing a rational judgment on the moral character of the act he meant to do, cannot be legally responsible for the act. Under this section 84 of the Indian Penal Code, an accused is protected not only when, on account of insanity, he was capable of knowing the nature of the act, but also when he did not know either that the act was wrong or that it was contrary to law, although he might know the nature of the act itself. He is, however, not protected if he knew that what he was doing was wrong, and even if he did not know that it was contrary to law, and also if he knew what he was doing uh, was contrary to law, even though he did not know that it was wrong. The burden of proof that the accused was of unsound mind, and as a result thereof he was incapable of knowing the nature and consequences of his act, is on the accused, which would be evident from the illustration A of section 105 of the Indian Penal Code. The burden of proving the existence of circumstances bringing the case within the purview of section 84 therefore lies upon the appellant. Every type of insanity is not legal insanity. The cognitive faculty must be so destroyed as to render one incapable of knowing the nature of his act, or that what he is doing is wrong or contrary to law. The court shall presume the absence of such insanity. The burden of proof of legal insanity is on the accused, though it is not as heavy as on the prosecution to prove an offense. The court must consider whether the accused suffered from legal insanity at the time when the offense was committed. And in reaching such a conclusion, the circumstances which preceded, attended, or followed the crime are relevant consideration. The prosecution, in discharging its burden in the face of plea of legal insanity, has merely to prove the basic fact and rely upon the normal presumption of law that everyone knows the law and the natural consequence of his act. There is a good deal of difference between medical insanity and legal insanity. It is not mere eccentricity or singularity of manner that would suffice the plea of insanity. Abnormality of mind is not by itself sufficient to show that the accused must have acted while of unsound mind. Such exemption can be claimed only when the insane person is incapable of knowing the nature of the act, or he is doing either wrong or contrary to law. In the case in hand, except putting the suggestion to the three witnesses that the appellant was a derailed person. Nothing has been elicited further, either from the cross-examination of any of the prosecution witnesses, or by adducing defense evidence, or by proving any medical document to show that there was any kind of unsoundness of mind of the appellant. The appellant's conduct at the spot is very relevant also to nullify the plea of insanity. His conduct of abusing the family members, the deceased at the spot, and reacting to the um, conduct of the deceased in forwarding him to leave that place, and his conduct in removing the axe from the site of the body where it was struck, and his conduct in leaving the place with the weapon of offense from the spot, all goes to show that he was not of unsoundness of mind at the time of occurrence. And therefore, we are of the humble view that the London Trial Court has rightly found the appellant guilty under Section 302 of the Indian Penal Code. The appeal being devoid of merit stands dismissed. ये कौन bail अच्छी ना? अच्छा. The appellant is on bail. It was granted by this court as per order dated 22/8/2014. He shall surrender within 15 days, and if not, the London Trial Court shall take immediate steps thereafter for his arrest to serve out the remaining part of the sentence.
Madam, pardon. Madam, may recollect, due to my lord's cross-examination in Court of Vigilance case, junior engineer, my lord has elicited cross-examination. The things were purchased, tender was done. Only lower quality. My lord was appearing for the junior engineer, I was appearing for the duty engineer.
See, one thing is that
cross-examination କିଛି ନାହିଁ।
ସେଇଟା ହଉଛି main vital. ଆପଣଙ୍କର ଇଏ ଟେବୁଲରେ କେତେ କାମ କରୁଛନ୍ତି, ଆପଣଙ୍କର ଅଫିସରେ କେତେ କାମ କରୁଛନ୍ତି, that is relevant. ଆଉ ଗୋଟେ ଜିନିଷ important ଯେ କୋଉ ସାକ୍ଷୀରୁ କଣ ପଚାରିବେ, କଣ ନ ପଚାରିବେ, ସେ ଜିନିଷ ମଧ୍ୟ ଜାଣିବା ଦରକାର. That is one of the basic things of art of cross-examination. And the persons who made gallery show na, they spoil the case. माने क्लाइंट अच्छी पछरे मु न पचारिले माने मो क्लाइंट कौन भाबिबो, ब्रीफ नहीं जीवो. सो ए जो धारणा रहीकिनी बहु जिनस पचारंती एवं जो जिनस चीप रे न थाए ताकू बाहर करंती. That's very fatal. So
before asking the suggestions also, one should be very clear that those things have not been really either stated by the witness, or for that you have sufficient positive evidence.
तापरे आ गोटे फॉल्ट बहुत समय करी बसन जे गोटे साक्षी टू सब गुडा को बाहर कर दो चेष्टा करत. मे नॉट बी, कारण किछि गोटे साक्षी कहि देला परे किछि कहि देला तापरे से कॉन्शियस हे जाय, सी तापरे पचारले सब. तणु को साक्षी टू कोन बाहर करिया पड़िबो, इट डिपेंड्स अपॉन हाउ यू रीड द माइंड ऑफ द विटनेस इन द डॉक. तणु those are all this, that is say cross examination is an art. Eta ku carefully.
Recently in one case, in one overhearing told that I was standing behind the veranda and it is not visible where the accused is sitting. I just stopped the cross
No,
examination.
if there is nothing to be, just stop it. Because
से देखी पारलानी
It's a
transaction
presumption.
से they stop कर देले. London vigilance asked me whether you put more question करना है पचारिए.
ना पचारिवर नहीं तो पचारिवर कौन? So when it goes in your favor, तापरे आपनकर से जो खंडे खंडे बाहर करी कि नहीं ताकू सजाड़ी भी at the time of argument ये साखी या कहला से साखी या कहला आ जो जिंस आपनक फेवर रे गोटे विटनेस कहि सारिछि
आउ तो पचारे
आउ अन्य साखी को पचारि कि नहीं
Answer to this.
नले कारण से माने प्रोसिक्यूशन क्लेवर हे जीवन ना जे ये जो एविडेंस टा पळे आइला ताकू केमती आउ थरे पचारा जाऊ ताकू नॉलिफाई करबा तेणु विटनेस को से ट्रेनिंग करथबे सब बेले सो इट बिकम्स वेरी डेंजरस इफ यू रिपीट दैट क्वेश्चन हां तेणु जदि गोटे विटनेस टू आनी देइछंती जे आसी परे पहुंचिला बेली आई विटनेस टू सेतळु डिसीज पडिथला खाली जस्ट आनी देवा कथा तमे जेतळ आसिलो तम संगरे आउ जो तीन चार आई विटनेस से माने भी सेति बेला आसी पहुंचिले stop the cross examination there and you are telling falsehood leave it there so you can argue at a different stage ye tago sangare asila ye to asi seti bele pahunchila ta sangare to ei mane asile to how they can be the eyewitnesses to there so but it all depends upon these are the actually what the it is not only in our state very very good councils were there were efficient now also of course few council are there in different districts but the new generation should be taught properly that how to cross-examine in contesting cases that is somehow lagging. It is the duty of the bar actually to invite the learned defense counsel who thorough in criminal law and ask them to deliver speech particularly to the younger generation so that it will be very helpful to them how to prepare the case, how to study the brief, how to keep the law in mind. माने आपण से जो AI या law अछि ए जिंस माइंड रखिले आपण जेरारे से जिंस गुड़ा को बाहर करिकिनी रखिदेले बाकी तापरे जेतेबेले आर्गुमेंट हबो से बही गोटे गोटे पॉइंट करथिबे ये करथिबे आनी सपोर्ट रे ए डिसीजन दोथिबे एटा ऑर्नामेंटल टाइप रो ये हबो अदरवाइज बट आउ रियल चार्म रहिछि ट्रायल appellate side re आपण करि पारंती but unless there is no as in this case if there is no जदि क्रॉस एग्जामिनेशन नाही आपण मुंडो पिटी देले कोन बारी जदि किछि वे आउट थिबो बाहरी अदरवाइज इट्स वेरी डिफिकल्ट क्रॉस एग्जामिनेशन नथिले
Oh, bless.
allowed. Same allowed.
Email on the last occasion, your lordship directed the state council to take instruction about the custody period of the appellant number 6.
P and 4, they have been
Already released on
Only
bail.
six
Only
was-
the appellant number 6 is in the custody.
okay.
He is near about 8 years in custody, my lord. 8 years, 7 months, 13 days till today.
Oh, what is the sentence imposed
10,
by the
10 years, my lord. Fine of rupees 1 lakh.
All right, heard the learning counsel for the petitioner is appellant number 6, Vikas Biswar. The considering the submission made by the learning counsel for the petitioner that the appellant number 6 has already undergone substantive sentence of 8 years and 7 months by now, out of 10 years of substantive sentence imposed by the Learning Trial Court. You have been released on interim bail.
My lord, 2 times I was.
And he has been granted interim bail 2 times, na?
My lord.
By this court.
By this court, my lord.
By this court, and after availing the same, he has surrendered at right time. And even though the paperwork has been prepared, there is no chance of early hearing of the appeal in the near future. And other appellants have already been released on bail. Samaste padileni.
My lord, 1, 3, and
some of the other appellants like the appellant number 4,
1, 2, 3, 4.
Appellant number 3, 4, 84 achi, out 3 and 4 like the have already been released on bail. And keeping in view the ratio laid down by the Honorable Supreme Court in the case of Muhammad Muslim alias so-and-so, I'm inclined, first like the Learning Council for the state has produced the custody certificate of the appellant number 4, which indicates that he has already undergone substantive sentence of, which is dated 6/6/11 or 5/11? 5/11/2023. Indicate that 8 years 7 party 8 years 7 8 years 7 months and 3 days is taken on that one. So bail application is allowed. Is a local man or
Local man of Malkanagiri, my lord.
terms and conditions so A6 granted bail only.
May I?
Yes. Why so many bail applications are there?
This is the for the interim bail application.
No. Apart from the interim bail, there are 2 interim applications. One is 867 of 21.
Seta may be permitted to withdraw, your lordship, earlier withdraw, and thereafter the petitioner released on your lordship granted 4 weeks interim bail for the death ceremony of his father.
Guru 867/21 to withdraw.
Regular bail again. Arata regular bail.
Wait, let us see. Neither who to withdraw him. Who to withdraw?
May I?
867 of 2021. This is an application for bail. The Learning Council for the appellant doesn't want to press this application. Accordingly, it is disposed of. Now you are pressing which interim application?
The recent 7/4.
2744.
2744.
That is an application for interim bail.
Interim bail.
On what ground?
The ceremony of the father.
Oh, first death anniversary.
anniversary.
So, what is your instruction?
Instruction ଅଛି ଆଜ୍ଞା
Tomorrow is
କାଲି
the
ଅଛି ଆଜ୍ଞା ଆଉ ଆମେ କାହିଁ
tomorrow.
କାଲି କଣ କେମିତି ଯାଇପାରିବେ
ଆଉ ହେଇପାରିବନି ତେଣୁ your lordship
Now,
consider
what is this application for bail?
bail your lordship the petitioner being the driver of the vehicle.
No, that was already rejected on merit, I think. Just a minute, let me see.
Your lordship କେବେ reject ହେଇନି ବୋଧେ.
You are granted interim bail
Yes,
on
sir.
30/10/2022.
ଆଜ୍ଞା
Then again,
4 weeks.
another that was 14/11/2022. It was granted.
ଆଜ୍ଞା
Oh,
at the time of the death of his father.
then extension was rejected and stay was fine. So, what is the sentence imposed?
Sentence 10 years, your lordship. The already 4 years above in custody, and the petitioner being the driver of the vehicle, the owner of the owners ଖାଲି driver ବୋଲି ଚାକିରି କରିଥିଲା ତାଙ୍କ ଗାଡି ଚଲାଉଥିଲା.
No, the period of detention is 4 years.
4 years.
Then you have not undergone half of the sentence.
Driver
So-
being the driver, your lordship, may consider.
So, 8 of Pardyantu, the IN number 2744 of 2023, though this application for interim bail was filed by the appellant to attend the first death anniversary function of his father,
Being his only son.
but the Learned Counsel for the state has produced the report from IIC Raghunath Police Station, Raurkela, which indicates that the first death anniversary is to be observed tomorrow. In view of such report, the Learned Counsel for the appellant doesn't want to press this interim application,
Oh, right.
so that is not pressed. IN number 1194 of 2022, this is an application for bail. Learned Counsel for the appellant submits that the appellant is in judicial custody for more than 4 years, and he has been granted interim bail twice, and after availing the same, he surrendered at right time. And the sentence imposed by the Learned Trial Court is for 10 years. Let the Learned Counsel for the state obtain the custody certificate of the appellant. Put of this matter, give a date. Yes. এইটাକୁ taken on record କରିଦେବେ
ପାଟନାଗର jail.
Yes. Yes.
Accusing
conviction under Section 21C of NDPS Act, my lord, sentence 10 years. Petitioner in custody 5/11/2020, my lord. This I filed for interim bail, my lord. The ground is only sister in marriage fixed on 24/11, my lord. You are now pressing this interim application? Yes, my lord. Interim bail application? Yes, my lord. 2698. 2698 of our 269895 कौन लिखा है जी? 95 ना 98? No, but ଏଥିରେ original ଲେଖା ହେଇଛି 95 ଲେଖା ହେଇଛି. फाइलଟା ଦେଖିଲେ 95 ଭଳିଆ ମତେ ଲାଗୁଛି. Your date is on 24/11/2023. Yes, my lord. So what is the report you have obtained? Yes, my lord, I have given. देखिए. No truth regarding the arrangement of marriage. So nothing is there. Lekhandu. IA number 2698 of 2023. This is an application for interim bail on the ground that that the marriage of the sister of the petitioner is going to be solemnized on 24/11/2023. Invitation card for the marriage has been annexed to the interim application. When the Land Council for the state was asked to obtain instruction on this interim application, today he has produced the written instruction received from IAC Model Police Station, Sadev Khunta, Baleswar, dated 14/11/2023, which indicates that the marriage of the sister of the petitioner is under process. However, the mother of the petitioner could not say about the name of her son-in-law and could not provide the marriage invitation card. And she further stated that Dolly is not her daughter's nickname. Dolly is one of the friend of her daughter, and she had already married. And therefore, there is no truth regarding the arrangement of the marriage of Namita Sethi with Vikas Sethi, which is scheduled to be held, which is stated to be held on 24/11/2023. In view of such report furnished, it appears that a false affidavit has been filed before this court by the mother of the petitioner for the purpose of grant of interim bail to his son. Issue notice to the deponent Jayant Sethi as to why a proceeding for contempt of court shall not be initiated against her for filing false affidavit before this court. A free copy of the order be handed over to the learned counsel for the state, who shall serve the notice on the deponent Juan Sethi through the inspector in charge of Sahadev Khunta police station. The date is fixed to 28th November 29th November 2023. The report is taken on record. Yes, next case.